Hello, everyone. I'm Judge Steven Teske, retired, and in this series, we examine one of the most important stories in American law and government today. What happens when the lawyers entrusted to enforce justice begin to fear the very system they serve? Across this series, we have been exploring and will continue to explore why experienced prosecutors are leaving the Department of Justice, how political pressure can distort legal judgment, why independent courts and state bars still matter, and what is lost when institutions ask for power but they stop earning trust. This is not a story about personalities alone. It's a story about professional duty, constitutional guardrails, and whether the rule of law can withstand the pressures placed upon it. This series is called The Bar Card and the Breakdown of Justice, and this is episode 3, and it's called What a Real Prosecution Looks Like. So before we begin, remember this. Titles are temporary. Power is borrowed. Integrity is tested when pressure arrives. And this is the Teske Brief. Welcome back. So apparently we now live in a time when half the country thinks every prosecution is political, and the other half thinks every prosecutor is Batman. But neither is true. Although, I will say this, to be fair, some prosecutors do love a cape made of moral certainty. So, why is it important to have a conversation about what a real prosecution looks like? Well, let me give you a brief glimpse into what the leadership at DOJ, the Department of Justice, has stated publicly about their version of a prosecution. And afterward, I will walk you through what a real prosecution looks like. Recent reporting describes statements by officials in the current administration that reveal a view of prosecution fundamentally at odds with the rule of law, and by the way, with the rules of ethics of every state bar in this country. And according to one report, White House Chief of Staff Susie Wiles acknowledged that efforts to pursue certain prosecutions were tied, at least in part, to the president's desire for score settling. I'm quoting her from a New York Times interview of her, and retribution against perceived enemies. Now, according to another, Ed Martin, the self-described captain of the Justice Department's so-called, get this, weaponization group. I tell you something right there if they're calling it weaponization, stated that if targets could not be charged, in other words, what he's really saying is that if we don't have enough evidence to charge them, they would still be publicly named and shamed. He reportedly said he intended to expose and discredit people he believed were guilty even when sufficient evidence to prosecute them could not be found.
Ryan, to name and shame, do we know what Ed Martin means by that?
Yeah, it is a major departure from what the Justice Department traditionally does, which is charge cases. There's, longstanding precedent and rules within the Justice Department about not using derogatory information against individuals when they don't feel as though they can actually go into court and prove that that person committed a crime. And that while derogatory information sometimes comes out over the course of an investigation or over the course of a prosecution, it's not something that you're bringing out against people when you're not actually bringing them to court. Here's a clip of what Ed Martin had to say.
There are some really bad actors, some people that did some really bad things to the American people. And if they can be charged, we'll charge them. But if they can't be charged, we will name them. And we will name them. And in a culture that respects shame, they should be people that are shamed. And that's a fact. That's the way things work. And so that's how I believe the job operates.
God, who died and made him king, right? Or better yet, in his head, who died and made him God? Those statements are extraordinary, more than extraordinary. Folks, in the law of legal practice, they are sinful because a real prosecution doesn't begin with revenge. It does not begin with score settling. It does not begin with selecting a person and then searching for a crime. And it certainly does not treat public humiliation as a substitute for proof. In fact, the law says that a judge okay, shall dismiss a case upon evidence that it was brought for purposes of selective prosecution. That is putting the name first. I'm taking you and I'm singling you out. Okay. A real prosecution, ladies and gentlemen, begins with evidence. It asks whether admissible facts establish a violation of law. It asks whether the case can be proven ethically and fairly. It respects the presumption of innocence. It understands that the process exists to protect the innocent as much as to punish the guilty. That is why prosecutors have long been expected to speak through evidence and court filings, not through threats, insinuations, or public shaming campaigns like Ed Martin is talking about. Speaking of shame, shame on him. The moment officials become indifferent to sufficient evidence, they become indifferent to the very safeguard that separates justice from abuse. The moment the government uses the process itself as punishment, prosecution becomes retaliation dressed in legal clothing. And the moment an institution charged with preventing weaponization openly embraces weaponization, the danger is no longer hidden, folks. It has been announced. That is exactly why this episode matters. Because before we can understand what a real prosecution looks like, we must be honest about what it does not look like. And what Ed Martin described, that's not what it looks like. So, what does a real prosecution actually look like? Because if you don't know the standard, everything looks suspicious, or nothing does. And both are dangerous. A real prosecution does not begin with, I hate that guy. It does not begin with, he embarrassed us on television. It doesn't begin with, can we make an example out of somebody by Friday? It begins with facts. That's right. Boring, stubborn, inconvenient facts. The kind that don't care who won the election or who trends online. Then comes the investigation, right? You interview the witnesses, you subpoena the records, you test contradictions, you look for corroboration, you examine defenses. And this part is important. You also look for evidence that helps the accused. Yes, I know. Shocking, isn't it? Oh my God. In some circles, that's now considered witchcraft. Then comes the grown-up question. Can we prove every element of the offense? Not, can we get a headline? Or not, can we scare them into settling? Not, can we keep cable news busy for a week? Can we prove the case? Huh? Beyond a reasonable doubt in criminal court? By a preponderance of the evidence in civil court? If the answer is no, my God, you don't file it. That's not weakness. That's professionalism. It's also called living in a civilized society. And if you think target first, evidence later is just an academic warning, let me introduce you to recent history. The Justice Department opened a criminal probe into the Fed chair, Jerome Powell. Big headlines, big drama, lots of insinuation. And then what? No evidence of a crime.
There is more evidence today that Donald Trump's retribution campaign, carried out by his Justice Department, is going pretty poorly. Brand new reporting in the Washington Post reveals just how weak a Justice Department prosecutor admitted their case against Federal Reserve Chair Jerome Powell really is. From the Washington Post, quote, a top deputy to U.S. Attorney Jeanine Pirro acknowledged in a closed-door hearing this month that the Justice Department did not have evidence of wrongdoing in its criminal investigation of the Federal Reserve over the cost of its building renovations, according to a transcript of the court proceedings.
Oh, a lot of big talk, a lot of hot air. A judge said the government had presented no evidence except that Powell had annoyed the president. You know, the whole thing about the interest rates, as if he's the only one who makes those decisions. It's actually a board who votes on it, okay? But this is an incredible new legal standard. Think about it. United States versus guy who was irritating on television. That's not justice. That's revenge with office supplies. And even when these cases fail, the damage can still be real. Lawyers' fees, reputation, stress, years lost. Because sometimes the point isn't winning the case. Sometimes the point is making the case happen. Here's something the public rarely hears. One of the most important things a prosecutor does. and that is to decline cases. Yeah, that's right. Sometimes the hero of the story is the lawyer who says, no, the evidence isn't there. No, this witness won't hold up. No, this theory belongs in a faculty lounge, not a courtroom. No, we are not turning vibes into felony counts. Look, folks, in my retirement, I'm still active. I wanted to go back before the bench. I'm practicing law. I'm actually in a prosecutor's office, okay? All right? And because I'm a retired judge and have practiced law longer than anyone else in the office, okay, my colleagues come to me and they'll ask me, Steve, would you take a look at this? I don't think we have enough evidence here, okay? And sometimes they will throw in there, I think he's guilty, but I don't think we can prove it. And I'm looking at declining it, okay? And I look at it. And every time they've come to me, they were right. And they declined it. You see, that type of decision making, ladies and gentlemen, protects innocent people. It protects credibility. It protects the system. Boy, it feels good to be in a prosecutor's office and my colleagues are ethical. They are professional. They are intelligent. Okay? They want to do what's right, what's fair. They want to do justice. A real prosecution is also independent. It doesn't mean prosecutors float through the sky like legal monks untouched by earthly concerns. It means they do not base charging decisions on the personal wishes of politicians, donors, pundits, or the loudest person holding a microphone. Look, let me tell you something. Don't think that our office from time to time, when we have declined to prosecute a case, hasn't heard from some political figure, okay, complaining, why didn't you do this, okay? And the explanation is given. But we come under attack. But we know we're going to come under attack from time to time when we decline to prosecute a person. Because that's what the law tells us we must do. Because once prosecutions become a reward and punishment tool for power, you still have a courthouse. You just don't have justice in it. A real prosecution is candid. You don't hide key facts. You don't mislead the judge. You don't omit the detail that destroys your theory and hope nobody reads footnotes. Prosecutors have extraordinary power. That means they have extraordinary obligations. If winning becomes more important than truth, the institution may win cases, but it's going to lose legitimacy. That's a terrible trade, and yet somehow one that people keep making. A real prosecution is restrained. This is another thing TV has ruined for us. Just because you can charge doesn't mean you should charge. Not every stupid act is a federal case. Not every jerk needs a grand jury. Not every public controversy needs a SWAT team and a press conference. Restraint is not softness. It is wisdom with authority. And yes, wisdom has terrible ratings. I get that. When the announcement of an investigation becomes more valuable than the evidence supporting it, the process itself can become the punishment. That may be great politics, but it's terrible justice. A real prosecution also accepts scrutiny. Judges review it, juries test it, appellate courts examine it, ethics boards can investigate it. History gets the final vote. That's not persecution of prosecutors. That's accountability. If your case is solid, scrutiny should not terrify you. If scrutiny does terrify you, we may have found the problem. So why are we talking about this now? Because when trust breaks down, people usually run to extremes. Either believe every prosecutor, no matter what, or every prosecution is fake. No, a free society has to do something harder. Support honest prosecutions, challenge abusive ones, respect the law, question power. That's called citizenship, for God's sakes. It's exhausting, I know, but I do highly recommend it. The Department of Justice doesn't earn trust by putting justice on the building. It just doesn't make it so because the word is there. It earns trust when it follows principles like these: evidence before accusation, judgment before force, candor before victory, independence before politics, restraint before excess. That's what lawful power looks like. And when those principles disappear, something else takes their place. Understanding what a real prosecution looks like is only part of the story. It is not enough to describe the ideals of fairness, evidence, and restraint. We must also understand where those ideals come from, why they are binding, and what happens when they are ignored. Because prosecutors are not guided merely by tradition or custom. They are governed by professional rules, ethical duties that define the lawful use of power and impose consequences when that power is abused. Those rules are not optional, ladies and gentlemen. They are the standards every prosecutor swore to uphold. And in the next essay, we turn directly to those standards. What are the rules? What do they require? And what does it mean when those entrusted to enforce the law begin violating the rules that govern themselves? That is where we go next. The rules they swore to follow. I'm Judge Steven Teske, retired. This is the Teske Brief. Remember this, justice is not proven by who gets charged, it's proven by how the decision was made. Until the next episode, ladies and gentlemen, take care and be safe. Goodbye.